Thank you, Diane, and welcome to the Alzheimer's Association Lunch and Learn call-in session. I need a will or do I need a trust? Today's session will answer this question and more. It will also be recorded and available for 24/7 listening on our website, www.alz.org/Long Island. You can also learn about other educational programs and services offered by the Association on the website or by calling the 24/7 helpline at 1-800-272-3900. It is a pleasure to introduce today's speaker, George Tilschner. His practice has focused exclusively on areas of the law affecting the rights and needs of senior citizens and estate planning, planning for people with special needs, including Medicaid applications and any resulting issues, long-term care planning, guardianships, and real estate. A frequent lecturer on the topics of elder law and estate planning, special needs, and Social Security disability, Mr. Tilschner has presented educational seminars before numerous community and professional organizations across Long Island and New York City, including the Suffolk County Bar Association and the Suffolk County Women's Bar Association. He is past president of the Suffolk County Estate Planning Council, a member of the National Academy of Elder Law Attorneys, the American Bar Association, and a member of the legal committee of the Alzheimer's Association Long Island chapter. Let's welcome George Tilschner.
Thank you, Kate, and thank everyone for participating in this little seminar today. My topic is wills versus trust. One of the most frequent questions that I get when I'm doing a consultation or even when I'm doing a seminar is, do I need a will or do I need a trust? What's the difference? I know there are a lot of seminars out there that trust seminars that say you must have a trust, everybody should have a trust, that it will help avoid probate and such, but I don't particularly work that way. What I try to do is I try to suit the needs of the client first. I sit down, I discuss the situation that this person is in, see who their potential heirs are, and see what their financial situation is, and see what to determine which vehicle would be best for them. In certain cases, a trust is definitely superior to a will, but not always. A trust is more expensive, excuse me, but a will, for the most part, will get the job done. Let's start with the will. A will, what it basically does is it sets someone known as the executor of the estate to probate a will. Once a person passes away, any assets that were only in that person's name are subject to probate. For example, if someone has a bank account and the bank account is solely in their name and there's no person to inherit it listed on the account, well, then that person, that bank account must go through probate. Similarly, if there's real estate in only one person's name, for example, I had a lady come in yesterday. She owns a piece of property in Florida. It's totally in her name, and she wants to protect it, and for Medicaid purposes. And I'll go into how we do that later on. But back to the will. The executor is the person who administers the will. The executor files a petition with the surrogate's court or has an attorney do it for them. Anybody who's due to inherit under the will, even if it's someone that is cut out. For example, sometimes people will disinherit one or more of their children for various reasons. Maybe sometimes it's because they don't get along. Other times I had one case where a woman disinherited one daughter because she had cared for her during her lifetime. She had supported her and wanted whatever was left in her estate to go to her other daughter. So she specifically disinherited her from the will. But that person still has to be noticed. The form has to go before the judge in the surrogate's court, showing that that person was noticed. And once everybody who has to be noticed has responded, the judge will then look at the petition, look at the waivers, and then he or she will issue what's called letters testamentary. And those letters can be used to access any bank accounts, any financial accounts, any brokerage accounts, buy or sell real estate. So those give the person the power to do all of those things. Until that time, basically the estate is in limbo because there's nobody authorized by the court to act on the estate's behalf. I usually also tell people to appoint a successor. Sometimes they'll have a they'll appoint someone, maybe a spouse or maybe one of the children as an executor. And if, God forbid, something happens to that child or that spouse, you want to make sure that there's a successor to be able to step into that person's shoes. So again, once everything is in order, and the original will must go to the judge, must go before the surrogate's court, along with an affidavit that says that the two people witnessed, and not only did they witness, but they signed an affidavit saying not only did we see the person sign the will, but we also noticed that they knew what they were signing. There was nobody, coercing them to sign the will, and to make sure that it's done with a certain procedure. In my office, we use certain procedures, such as the fact that I say the same questions to the people all the time. I ask them if it's their last will and testament. Have we discussed its contents? Does it reflect your wishes? Would you like the witness to witness and the notary to notarize their signature? Once a person says yes to all that, I have them initial each and every page, and then sign and date at the end. And that is a will. And for the most part, a will do the trick. For people with middle-class people with modest estates, a will is perfectly fine and it will get the job done. However, going to the other side of the coin, why a trust? A trust has certain advantages in the sense that assets that are titled to that trust do not have to be probated. So the successor trustee, if the person is the person who's drawing the trust is the initial trustee, the successor, once that person passes away, is free to collect all the assets and hand out the bequests according to the terms of the trust. And that can be done immediately. Whereas with a will in Nassau and Suffolk counties, maybe 6 to 8 weeks to probate a will. It's not a difficult procedure. Doesn't take years like some people say it does. It can if you're in one of the 5 boroughs in Manhattan. It could take a really long time. Manhattan, Queens, the Bronx, and such. It can take a while there. But out of Nassau and Suffolk, the surrogates courts generally work pretty quick, and they get the job done. But if you have that trust, you don't have to wait that period at all. The trust also is a private document. It's not a public record like a will is. If you wanted to go to Riverhead or Mineola, you could look at any will that's ever been probated in those counties, and you can see copies of them, and you can see copies of all the paperwork that was filed along with the will. Whereas a trust is simply a device that again voids probate and keeps the trust private. You might notice many times that a celebrity will have a will and a trust. They'll have a basic will that they maybe hand out some bequests, but anything that's complicated stays in the trust because the trust doesn't become a public record and nobody has access to it. Whereas, once again, a will is. A trust, there are several different kinds of trusts. Now, let me going back 1 second. Not only is the trust not available for probate and it's not a public record, but there are no real tax advantages to it. Like some people think. It's basically looked at in the same way as a will in that sense. Now, there are several different kinds of trusts. There's first one is called the revocable living trust, and that is simply a way to avoid probate, or such as the lady who came into my office yesterday who has a real estate in Florida, in order to avoid a probate in 2 different states because she has property here in New York and property in Florida. So that I told her definitely she should put the Florida property, because she's going to remain living up here. She's going to put the Florida property in a trust, and she's also going to put her house up here in a trust because that'll be the second part that I'll go into the irrevocable trust. But let's stick to the revocable for a second. I always recommend, again, if someone has a property in another state, to put that property in a revocable living trust in order to avoid probate in 2 different states. Because if she left that parcel of land titled only to herself when she passes away, her heirs would have to do a probate in Florida as well as a probate in New York. So in order to avoid that, I always recommend the revocable living trust or an irrevocable trust for out-of-state property. Trust can also be formulated within a will. In my wills, what I do is I provide everybody with what's called a supplemental needs trust. Supplemental needs trust will protect any individual who would inherit under the will, who might be receiving government benefits such as Medicaid, and whose benefits would be affected by them getting an inheritance. So what I build into the will is a supplemental needs trust that says I want my son or daughter or my husband or whoever it is or wife to inherit, but if they are either in a nursing facility or their benefits would be affected by them getting an inheritance, the money does not go directly to them. The inheritance goes into a trust. A trust is administered by a trustee who is set up under the terms of the will, and it can be used for any purpose to help the individual whose inheritance it is. The only things that cannot be used are anything that Medicaid or Medicare would cover. So it'll cover all their needs. It will cover if they needed to go on a trip, if they needed a special car, whatever. It can be used for any benefit whatsoever, but the person's name is never on the trust. It's for their benefit, but it's set up under the terms of the will. One can also set up, a supplemental needs trust standalone basis, inter vivos, which means a living trust. I have several clients, numerous clients actually, that have children with disabilities, with special needs, and they want to set up a trust now for them, as well as under the terms of their will. So we can do that. We can set up a supplemental needs trust, and the person can fund it. The dad or mom both can fund that trust for the purposes of their child, and that child will be able to reap the benefits of that now. Whereas a trust set up under the will, nobody reaps the benefit of that until the person passes away. So that's also a good tool to use, because it will protect the person's assets, and it will allow them to keep any Medicaid benefits or any kind of government benefits that are needs-based. Medicaid is a needs-based benefit. One can only have less than $14,850 in their name in order to receive Medicaid benefits. Many times, and I know I'm veering off the course for a second, but I think it's important to point out that Social Security disability, which a lot of people confuse with Medicaid, Social Security disability is not means tested. You can win lotto and still get your Social Security disability because it's only based on your ability to work, to perform substantial gainful activity. Whereas Medicaid, once again, is based on your assets. So there's a big difference between the two. And it's a point that people often get confused with. The other type of a trust is an irrevocable trust. Now, the irrevocable trust is set up to protect people's assets for Medicaid purposes. The revocable living trust, I can set up a revocable living trust. For example, I'll give you an example of a client. She came in, she has a house here in Huntington, New York, where my office is. She also has a place in Pennsylvania. And what we did was, in order to coordinate everything completely for her, we put both of those houses into the revocable living trust, and she is the trustee of that trust. So the asset remains available to her. It's no difference other than the titling of the deed. The deed says so-and-so as trustee of the John Smith Trust, John Smith as trustee of the John Smith Revocable Living Trust. So they can still have access to any benefits. If they put bank accounts into the trust, they still have access to those under the Revocable Living Trust part. Now, if someone sets up an irrevocable trust, the thing that allows the asset to be protected for Medicaid purposes after a 5-year look-back period is the fact that the asset is not available to the person. So that if someone, I always recommend this to people, don't put liquid assets in the trust if you're going to actually need them at some point, because you won't have access to them. The trustee will have access to them, but they can't give the asset to the person who's setting up the trust. So most of the irrevocable trusts we do are set up for real estate. For example, mom and dad want to protect their home for Medicaid purposes. So we'll deed that over to the irrevocable trust, and we put what's called a life estate in the trust. A life estate allows the person to live in the house for the rest of their life. House can't be sold out from under them. It allows them to keep any real estate exemptions, which is important. If someone has an enhanced star exemption, they want to be able to keep that enhanced star. But because by putting the life estate in the deed and in the trust, that person is allowed to keep their exemptions. So it's a good tool to protect an asset, especially a real estate asset, because if they decide, and we've done this many times, if a person has decided they wanted to, say, downsize, or they wanted to buy a smaller house or a house in another area, The trustees of the trust the trustees of the trust cannot be the person setting it up. So mom and dad set up a trust, an irrevocable trust for themselves. They're what's called the grantors, the people who are setting up the trust, but the trustees have to be someone else. Because once again, the mechanism that protects these trusts for Medicaid purposes is the fact that the person has no control over the asset. And if Medicaid is filed for down the road, of course Medicaid will want to see the trust to make sure that it meets their standards. And once they do that, the house is protected. And if they wanted to sell the house and replace it with another one, the trust would sell the house. Proceeds from the sale would go into the trust, and then the trust can purchase a second house for the people using those assets. The only thing is, if there's a differential between what they sold the first house for and what they bought the second house for, any overage or anything that's left after purchasing the second house has to remain in the trust. But once again, after 5 years, the house is protected, and if someone needed to go on Medicaid, then they would certainly be able to. That would house definitely protect it. An irrevocable trust can also, if liquid assets are put in there, the trust can be phrased such that any dividends or any interest that the asset garners can be turned over to the grantors. That can be put into the terms of the trust. A trust also, a living trust, an irrevocable living trust or an irrevocable trust, also basically act as a will. You say who you want your assets to go to after you pass away. Any terms, any specifics, like say you wanted to leave cash to an individual, a friend, or a charity. I have many people who set up under wills and trusts. They set up charitable bequests. I want X amount of dollars to go to North Shore Long Island Jewish. I want it to go to the ASPCA. Some people don't have relatives, and they want all their money to go to charities. In those cases, I generally always set up a trust for the person. And what we do is we name the charities in the trust. If someone wanted to leave money to the Alzheimer's Association of Long Island, we set up the terms of that in the trust, just so that and in the will as well. If some people would rather go with the will way, but the trust it expedites the charitable organization getting their bequests. Does anybody have any questions so far? Okay, we'll take that as a no for right now.
I'm sorry. I apologize. Your first question comes from Melissa. Go ahead, ma'am. Your line is open.
Hi. I just had a question. I was curious to know, do you know of any cases on Long Island where Medicaid has actually gone after or put a lien on the family home?
Well, first of all, Medicaid can, let's put it as a husband and wife situation. Say husband goes into the nursing home and wife lives in the home. No Medicaid lien could ever be put on the property until both people pass away, and then they could place a lien. I know of no cases in Nassau or in Suffolk that litigation has actually been commenced. Suffolk doesn't even really send out threatening letters. Nassau does, but I've never seen them follow up on them yet. I have litigated some issues in New York City where the entity, the Department of Social Services, or in New York City it's the 5 boroughs, it's the Human Resources Administration. Here it's the Department of Social Services. They have initiated lawsuits against surviving spouses. They have attempted to put liens on homes. But here in Suffolk, the only way, and Nassau and Suffolk, but this part is good for all of New York, a lien can only be placed on a probatable asset. So in that sense, by placing the house in a trust that does not have to go through probate, that would eliminate the possibility of a lien being placed on any property of the trust. So, for example, if the house is still in the person's name, let's say a single person, the house is in that single person's name, he passes away. Since that now has to pass through probate, or even if he has no will, through an administration proceeding, Medicaid can then place a lien on the property. But let's say when Medicaid was applied for, or before that, he placed the property into a trust, an irrevocable trust, or even irrevocable, that asset does not pass through probate, so there is no possibility of a lien being placed on that property. So all in all, I've not seen Medicaid in Suffolk County, Department of Social Services go after anyone. I even had what I thought was going to be a test case. I had a client. Wife went into nursing home. We transferred all the assets to the husband, including the house, and by filing what's called a spousal refusal, meaning it's just a statement saying I refuse to be responsible for the health care needs of my spouse. By filing that spousal refusal, they could look at the assets that the community spouse has, but they have to make the Medicaid determination based only on the assets of the person applying for Medicaid in the nursing home. These people, particular people, had assets of a couple of $1 million, and so I told the client that although Suffolk has never tried to sue a community spouse or place any liens, you might be the test case. And even when I filed the application at that time, the application was filed during a face-to-face interview with a caseworker, and that's no longer the case now. But at that time it was, and even the caseworker said to me, you might have a test case here. But it went straight through, no problems and no issues. So I guess the bottom line is the only time a lien can be placed by Department of Social Services or the Human Resources Administration is when the asset goes through probate or administration. If the asset is in a trust or has a designated beneficiary on it, then it goes directly to those beneficiaries with no possibility of a Medicaid lien.
Okay.
So I just want to, finish up by saying that it depends, again, like I started out in the beginning of the hour. It depends on the person's needs, whether they have a will or a trust. I think if in the simple situation, mom and dad of modest asset level, there's no real need to spend the extra money on the trust unless they're trying to protect something for Medicaid purposes. So in that case, in the very standard case, I will always usually recommend a will. And one thing I didn't say is that I don't generally do typical "I love you" wills. I love you, you leave everything to you. You love me, you leave everything to me. I add something to that because obviously, usually, husband and wife want to leave everything to the surviving spouse and then to their children. But what I do is I mentioned the supplemental needs trust before. I do a specific one for the spouse, the community spouse, and it says, yes, I love my wife. I want to leave everything to her, but if she's in a nursing facility and she's receiving Medicaid benefits, then I have it go straight into a supplemental needs trust to supplement their care. It kind of puts a little extra emphasis on protection of assets. So we do add that into our wills as well as the supplemental needs trust for any beneficiary. But I also put that language into a trust. But again, I think for most middle-class people, unless they have specific needs that require a trust, like a supplemental needs trust, or they have property in another state, unless they have that, in the standard case, I'll do a will for the persons, because I think that to have them spend extra money on a trust just for the basis of having a trust, it doesn't really pay. I do explain the difference between them to all clients. I say, okay, here are the benefits of the trust as I laid them out earlier in the hour. And here are the benefits of a will, and here's the drawbacks of a will, and let the person make the decision. I tell them what the cost of each, to prepare each one would be, and let them make their decision. But for the most part, for regular, normal, middle-class people, I think the will is fine. A trust, once again, just to sum up, the trust avoids probate. It provides privacy in the sense that it's not a public record as a will is, but those are the only, and it makes life easier for the beneficiaries after the person passes away. So those are the main benefits of a regular living trust. And the Medicaid trust, the irrevocable trust, we prepare more and more of those for people to protect their residents. It used to be Before 2006, there used to be a 3-year look back for everything except the trust or an IRA, which have been a 5-year look back since 1993. But in 2006, the laws changed, and every asset is subject to a 5-year look back. So before that, we used to suggest, okay, maybe to save a little money and because of the 2-year difference in look back, instead of putting the house in a trust, deed the house to the children, reserving a life estate for mom and dad so that the children can't sell the house out from under them, and they still, once again, receive all their real estate exemptions. They keep those. I don't like doing those as much. I don't do as many now because there are certain drawbacks to having the house basically in the name of the children. Should they become involved in a judgment creditor case, there's a potential for a lien on the house. But when there was a 2-year difference in the look back, it was sometimes worth the gamble. But now I recommend to everyone, because there's also more flexibility by putting the house in the irrevocable trust as opposed to the deed transfer with the life estate, because with there's less flexibility to sell the house. Because basically, if you sell the house with the deed with the life estate, deed to the children with the life estate has a value as long as the person is alive. And if the house is sold, then technically the person is supposed to get the value of that life estate. And if the person is already on Medicaid, that would be an issue because that would be considered an asset that Medicaid would demand be spent down prior to Medicaid being reinstated. So Medicaid would cease. The people would have to privately pay with that money from the life estate, and then Medicaid would step back in once the money is spent down. The other drawback to the deed transfer with the life estate is the fact that there's no step up in the cost basis if the house is sold during the life tenant's lifetime, meaning that if someone has a cost basis of $100,000 and the house is now worth $300,000, the children will be subject to a capital gain on the difference between the two, the $200,000 difference. If the house is not sold during the life tenant's lifetime, then the children would receive the step up in the cost basis. And the same is true to a trust. The children would receive the step up in the cost basis when the parents passed away. And the biggest benefit of the Medicaid trust or the irrevocable trust is the fact that you can gain protection of that asset from Medicaid, and after 5 years you don't have to worry about what's going to happen if I go into a nursing home. Were they going to take my house? Well, nobody takes the house, but what they do is that, again, they couldn't place a lien on it. If it's in a trust, they can never place a lien on it. If it was the deed transfer to life estate, they also couldn't put a lien on it because it would pass directly to the children by operation of law. So a lien can only be placed on an asset that has to go through the courts, and anything that's in a trust or the deed transfer to life estate does not go through the courts. If there are no other questions, I want to thank everybody for coming to the program today and for listening to it in the future on the Alzheimer's Association website. And it's been a pleasure, and I thank the Alzheimer's Association for allowing me to speak today. And have a great day.